Assam compulsory registration of
The Assam Legislative Assembly on August 28 passed the Assam Compulsory Registration of Muslim Marriages and Divorces Bill 2024, a proposed law with the stated objectives of preventing child marriages and marriages without the consent of the parties and to check polygamy. The Assam Assembly also repealed an existing 89-year-old act for the registration of Muslim marriages and divorces in the state, confirming an ordinance promulgated 5 months ago. In this video, we will take a look at the key features of this new law in Assam. Let's get started. The bill passed by the Assembly regulates marriage between two Muslim persons, which includes nikah or any other ceremony by which two persons are made husband and wife following Muslim personal law and Islamic rituals. That said, here are some key features. First, there is no role for qazis in registering marriages under the new law. The registering officer shall be the government's marriage and divorce registrar in that jurisdiction, who is the sub-registrar. Number 2, for a marriage to be registered under the new law, 7 conditions must be fulfilled. Important among these conditions are: the woman should have attained 18 years of age and the man 21 years of age before the marriage. The marriage has been solemnized on free consent of both parties. At least one of the parties must be resident within the district of the marriage and divorce registrar for 30 days before giving notice of registration to the officer. And the parties shall not be with the prohibited degree of relationship as per Muslim law. Now, moving on to other key features. The parties are required to give the registering officer at least 30 days notice before the intended registration with documents attesting to their identities, age and place of residence. This provision is similar to one in the Special Marriage Act. Objections to the marriage are allowed within the 30-day period on grounds of violation of any of the conditions laid down in the bill, which will then be inquired into by the registrar. If the registrar, after inquiry, refuses to solemnize the marriage, the bill provides for 2 stages of appeal: to the district registrar and then the Registrar General of Marriages. The next one, the registering officers must act if they find that either of the parties is underage. If the officer makes this discovery during the scrutiny of documents, she must immediately report it to the jurisdictional child marriage protection officer appointed under the Prohibition of Child Marriage Act 2006 and transmit all relevant records for the effective prosecution of persons contravening the provisions of the Act and for initiating appropriate legal action. Then another feature, an officer who knowingly and willfully registers a marriage that violates any of the conditions is liable to be imprisoned for up to a year and fined up to 50,000 rupees. And lastly, the bill states that its provisions shall be in addition to and not in derogation of the provisions of the prevailing Muslim personal laws. However, under Muslim personal law, the marriage of a bride who has attained puberty is considered valid, and puberty is presumed in the absence of evidence on completion of the age of 15 years. Earlier this month, the Supreme Court agreed to an early hearing of a plea by the National Commission for the Protection of Child Rights, seeking an authoritative pronouncement on whether Muslim personal law allowing child marriages will prevail over the Prohibition of Child Marriage Act 2006. And this is a question on which different high courts have made differing observations. That's all for today. If you like this video, then don't forget to subscribe to our channel, The Indian Express. Thank you so much for watching.